Hi, y'all, and welcome to the recap of day 8 of the Donna Adelson trial, which is without question the strangest, most bizarre day of the entire trial. It was strange start to finish, including the enormous angst that Donna Adelson displayed over whether or not she should testify. It went back, it went forth. Would she testify? Would she not? We waited for all day. And the judge gave her 5 minutes more to decide, and 5 minutes here. And finally, the decision came in. Donna Adelson, spoiler alert, will not testify. But we are moving straight into closing arguments in the morning. You've got to hear about today. It was absolutely crazy. And it started out of the gate. The first thing was so bizarre. When the court feed cut in, it cut in with a statement something from the defense. We're not accusing the prosecution of doing something to prevent us from talking to witnesses. What? What would even think that? Apparently, there was a person at the sheriff's office that they were supposed to speak to. Sounded like an officer working with the sheriff's office. They went to speak to that person, and for some reason, they believed this person had information and was willing to talk to the defense. But what happened was that the officer announced they were no longer willing to speak with them. Apparently, they weren't even allowed to see the officer. They just got the message the officer was no longer willing to speak to them and was not available, was on leave. So, shades of something like we might have seen in Karen Reed case, right? This is sounding like the sheriff's office is getting in the way of Donna Adelson being able to get information. Are they withholding? Is there someone who has important information and they're not letting them have this? But it quickly devolved from there. The judge said, "Okay, do you have her under subpoena?" And they said, "No, we don't. We haven't even talked to her. We don't even know exactly what she's going to say. And maybe we don't want her under subpoena because it's not good for us. So, no." And the judge said, "Okay, we're in the middle of trial here. And this is a brand new witness. And it's furthermore a witness not even under subpoena." It apparently was a deputy named Franklin. They put the sheriff himself, I believe it was the sheriff himself, under oath. And the sheriff testified that Deputy Franklin went to her captain, who came to him, and he talked to the legal counsel for the sheriff's office. And here's what they came up with. Franklin had come to her captain and said, "Do I have to speak to these guys?" And the sheriff and the counsel said, "You can if you want to. But if you don't want to, then the defense is going to need to show you a subpoena in order to make you testify or talk to them." After all of this, the defense said, "Well, we just wanted to put it on the record. We're not going to pursue it." I don't think it will be an appellate issue because they aren't going to pursue it. So, what was that about? We will never know. The next witness was Kristen Adamson. All morning was attorney morning. We heard from attorneys. Both of them were family law attorneys. The first one, Kristen Adamson, represented Wendi Adelson. Wendi was, of course, the daughter of Donna Adelson, who's on trial, and was in a bitter custody battle. At least I've called it repeatedly a bitter custody battle with her ex, Dan Markel. But the point of both of these witnesses was to say it wasn't really that bitter a custody battle. It wasn't even that big a deal. And it wasn't all that hard fought. Everybody seemed to pretty much resolve it and get along. That was a large part of what these witnesses had to say. So Wendi's attorney said she would not call this a bitter custody battle. She said, yeah, they had an argument over relocation. And she told Wendi that you can ask for relocation, but you're only going to get one shot at that. You have to do it during the divorce proceedings. Doing it afterwards, getting a modification, you're never going to win that. And it's going to be hard to get even initially out of the gate if you ask for it in your divorce proceeding. As of today, she said, "I've only won relocation once." So this is very rare, very hard to get. So the hope that Donna and Wendi had of getting the kids to be able to move to South Florida nearer Donna and Harvey, that wasn't going to happen. Not through the courts, not through this motion. Very unlikely. And sure enough, Wendi did not win relocation. She did not get the judge to order that the kids could be moved to South Florida. So Wendi could still offer a financial incentive to Dan to move. And that was discussed in the family. We have often heard it referred to by the state as the $1 million bribe. They could pool their money. It depends on who you ask, but Donna and Harvey would pay a third, Charlie would pay a third, and Wendi would pay a third unless you asked her, in which case Donna and Harvey were both paying a third and she was paying nothing. But they were going to offer $1 million to Dan Markel. This was Donna's idea, not necessarily anyone else's. But if they offered this $1 million, it would be, according to Wendi, a way that Dan Markel could move to South Florida and still travel back and forth to his job. So he would be living near the kids. There wouldn't be a problem with seeing them. The only inconvenience of traveling to Tallahassee to teach his law classes would be covered by the money they were going to provide, this $1 million. And the attorney said there's nothing wrong with that. It's pretty common to it's a negotiation. You're trying to work out where the kids will live. So if money makes it easy, you just try to figure out how to make it all work. Now, of course, we know that Wendi testified that she never even brought it up with Dan, and it might have been an idea Donna had, but it never even got mentioned. It never got out of the gate. The cost of this litigation with Dan Markel, the attorney said, was about $30,000, which wasn't that much compared to a case that really went through litigation, meaning went through discovery, went through the trial process. That would cost a lot more. At the end of it, there was a deal where Dan Markel still owed some money. Two things in particular. He was going to pay Wendi $120,000, which he did not. He was also going to pay her attorney $10,000, which he did not. Those amounts were outstanding, and the attorney said she asked repeatedly for them, tried to push for them. He wasn't paying. At long last, she finally moved to force him to pay that. It was a motion for contempt because that's what you call it. But we were told it's not the kind of contempt where somebody goes to jail. At that point, Dan Markel came up with an argument. Dan Markel said he really shouldn't have to pay that money, although the witness said he had fully agreed to it in mediation. It was part of the order. He had to pay it, but he shouldn't have to because it turned out Wendi had hidden certain assets. And the attorney for Wendi at the time, Kristen Adelson, said that was false. We have been in the middle of a mediation when issues about this arose. We called the person from Charles Schwab. We got him to detail exactly what accounts there were, who owned what, which ones predated, which ones were marital assets coming in the marriage, which ones were non-marital assets that were not going to be shared. And we got it all worked out. That was part of the deal. We were not hiding assets. The witness said, and we heard this from the second witness as well, that she believed it was Dan Markel writing these motions, that it just sounded like not a family law attorney. It seemed more like Dan was doing it. The judge's reaction, according to Kristen Adelson, was to be very unhappy with Dan Markel and Dan Markel's pleadings, that they were not appropriate, and to tell Dan, this is not the way it's done. Dan Markel, around this time, began bringing up parenting issues, and he filed a motion and asked that Wendi and her attorney be disbarred, saying they had committed fraud. He also talked about parental alienation claims. These were claims that Donna was making statements to his children with Wendi, and they were statements about him that were negative about him, like that he was dumb and trying to take her loves away. But the attorney told us that it would not reduce Donna's time, that this motion was absolutely nothing. This idea that Donna was alienating their affections for these comments, that's not going to reduce her time. And Kristen Adelson said, I told Wendi that. I told Wendi this is a nothing. Do not worry about this. At this point, though, Kristen Adelson realized she was going to have to be a witness. So she withdrew because now she was going to have to testify in the case, and she couldn't both testify and also be the person who represented Wendi. She got someone else involved to represent Wendi. Donna was not overly involved in the case, she said. In fact, the only thing she really ever heard from Donna was that Donna came to the relocation hearing. She thought she maybe stayed outside. And Kristen Adelson said, as divorces go, this was not a particularly contentious one. The enforcement, when they got into the part where they were fighting and Dan Markel was filing his new motion, yeah, that was pretty contentious. And his pleadings were very personal. But frankly, that was Dan, not Wendi. And that was Dan doing it after the divorce was finalized. You were hearing my recap of what the witness said while the witness was testifying. Don't worry, we will get to cross-examination. You will hear what happened on the flip side as well. The next witness was Linda Bailey. She testified to almost the identical thing that we just heard from Wendi's lawyer. She testified to all of that related to the question of what exactly Dan Markel had done, what they had agreed to, and what this grandma motion that we've heard so much about from the state, what did that actually mean? So Linda Bailey followed up. She was an expert witness. She came right after Kristen Adelson. Linda Bailey, apparently, and boy, did this get the judge upset. Linda Bailey was in the courtroom during the testimony of Kristen Adelson. Now, in this case, there has been a rule of sequestration was invoked, meaning that the witnesses can't hear each other. So a witness has to stay outside the courtroom and not hear the testimony until it's time for them to testify. And then once they finish, if they're released, they can hear what everybody else has said. But what they can't do is come in, listen to the testimony, and then potentially have it affect what they said or what they thought or what they remembered. That's the reason for the rule. Well, in this particular case, there was an exception made to this. The exception was that the experts for one side could hear what the experts on the same topic for the other side said. The defense asked for an exception, and that's the part that the state agreed to. So that was the part that became the exception. The defense wanted more. Apparently, this witness, Linda Bailey, all along wanted to listen to Kristen Adelson, but that wasn't what the state agreed to. And so what you had was Linda Bailey listening, even though that hadn't been agreed to, and she wasn't supposed to under the agreement they had made. So at this point, the judge said, this is not what the state agreed to, went back and looked specifically at the transcript where there had been discussion between them, what had each side said, and said, look, this is the second time, defense, that you have violated the exclusionary rule. This is the second time you've let someone listen to testimony when they're not supposed to, and thought long and hard about whether to let this witness in at all. The state said exclude the witness. She heard testimony she wasn't supposed to, keep her out. So there was a proffer at this point. That means they offered some evidence to give the judge an idea of what he would be ruling on, and of course it'd be available for appeal as well. The jury didn't hear this part. So the witness, Linda Bailey, came in. She's an attorney as well, also a family law attorney. And she said she had asked to be able to sit in to Kristen Adelson, and that she wanted the reason she wanted to sit in for that was that she wanted to confirm she had all the facts correct, and she concluded that she did. The state said, and the state did one question for her on cross-examination during the proffer, was there anything new that you learned? And the answer to that was no. She said, no, there wasn't. So the judge came back with some findings. He said, look, I'm finding this is a second violation, second time you've done this in this trial. And you could tell he was upset too, may I say. And he said, Bailey should not have sat in the courtroom. That shouldn't have happened. But here's the deal. The test set out by the appellate courts for me to follow was the testimony substantially affected by what the witness heard? And did it differ from what would have been said if they hadn't heard it? Well, that's a really, really high standard, and essentially means that unless something unusual is going on, rarely should they exclude anyone from testifying. And the judge said, look, she's got credibility. She's a member of the bar, so I'm going to assume that what she told me is correct. And what she told me is She was not substantially affected, so I'm going to let her testify, but I'm going to give the jury a special instruction at the end about the fact that 2 witnesses violated this rule and heard testimony when they should not have. So we got finally to Linda Bailey, family lawyer, and she said Wendi was really not trying to force a very unreasonable deal on custody on Dan Markel, that she was offering him from the beginning 40%, I think it was 41%, and that was not preventing him from substantial, she called it time sharing or custody of the children. That was pretty good. She wasn't being unreasonable in what she was asking. In the end, they worked out 45% to Dan, 55% to Wendi. The attorney, Linda Bailey, said, look, this wasn't all that highly contentious, and it was moving fairly quickly as cases like this go. It was 10 months and it was done. Donna's involvement also was, if anything, understated. A lot of mothers get involved. Donna was not unusually involved in the case. She looked also at those motions that Dan Markel filed in the last 10 months or so, maybe a year. And she said she agreed that Dan Markel was drafting them. They did not look like anything an attorney who had any skill or knowledge in the area would understand because they didn't fit with the way family law works. She thought that Dan's argument that I don't have to pay that because Wendi withheld information, that was not a strong legal position. He was not very likely to win on that. That Donna emailed Wendi just a few days after the relocation was lost. And yes, at that point, she was really thinking they could still fix this. There was a chance they could maybe make it work out. And Wendi responded to her, look, Mom, I'm at peace. I'm good. And at that point, Donna, from the review of emails she'd seen, seemed to drop it. And they managed to split custody fairly evenly, 45 Dan, 55 to Wendi. And after 3 years, it was going to go to an even 50-50 once the kids were in school. Dan Markel, on the other hand, she said was asking for something highly unreasonable, like sole decision making for the children. She said that never happens. That is totally out of the question. No one was going to do that. And her final judgment, the final judgment in the case, was favorable to Wendi, but only in the sense that Dan was asking for really extreme things. It was very fair and very typical. That Donna had grown to accept that Wendi was going to stay in Tallahassee, and that it's very reasonable and normal to pay someone to relocate. She didn't see anything unusual about that. That he did. And she talked specifically about the grandma motion, because this is at the heart of the state's argument about why Donna would want to murder Dan Markel. After all, what's the reason? And what the state says is he was standing in the way of getting those grandbabies down to South Florida where she could spend more time with them. She didn't want that. And so having reviewed what he had filed, Linda Bailey said, well, he wasn't asking for her to not be allowed to have unsupervised visitation. That's not what this motion really says. That, first of all, it was 8 points down, 10 pages into the motion that he filed. And it never said anything about Donna not being allowed to have unrestricted time or always having to have supervision when she was with the children. Instead, what it said was that instead of Donna coming up and getting the children when Wendi went out, basically being the babysitter, instead, the right of first refusal would belong to Dan. So if Wendi was going out, he would get to say whether or not he would get to be with the kids or not. Although you can see if someone was really committed to that, then you can see where it would be hard for there to be any time left over to spend with the grandparent. I mean, you can see where that could go fairly far. The witness said, well, that's not how right of first refusal works. Said that this is not designed to prevent you from having sleepovers with your friends or from spending the night with grandma. This is supposed to be about longer term, bigger issues. That entire motion by Dan Markel that included the grandma motion part, it would not have been well taken by the judge. according to Linda Bailey. It was baseless, and she called it a complete waste of time and money, that it was ridiculous. It was not going to get accepted by the judge. During this period, while the jury was out, one of the attorneys, Jackie Fulford for Donna Adelson, asked for a sidebar. And when they came back, the judge made a very stern instruction, more than once today, might I add, telling the gallery, no expressions, no motions, do not do anything that could influence the jury. So cross-examination was fairly brief, but really powerful at the same time. The primary point of the cross-examination was, it doesn't really matter what Linda Bailey thinks, what Kristen Adamson thinks about whether this is an unusual case. What does matter is whether Donna Adelson thinks it's an unusual case, or forget even unusual case, whether she thinks it's bad for her and whether it gives her a motive. That's the real question. So at one point during the examination of Linda Bailey, we had kind of a my cousin Vinny moment. You may remember back to Charlie's trial, a moment when Georgia Kappelman brought up a big notebook of the file for Wendi's divorce case and plunked it down on the desk in front of her and said, is this your divorce file? Huge thing, right? All it was one notebook, granted, thick notebook, that thick. Well, they went through more details with Linda Bailey, the defense did, Donna's team, and they said total pages in her file was about 550. That was the file between Wendi and Dan. Whereas they brought up another file that Linda Bailey had worked on, and it had 10 notebooks. And she said there was another file she had that had 20 notebooks. Their argument being, this is a heavily contentious divorce case. The one with the 10 notebooks or the one with the 20 notebooks, that's big. That's really big. And they were stacking them up. They had boxes on them. It was definitely a my cousin Vinny moment. But the cross was just pretty simple. Okay. Granted, to you, it might take 10 notebooks to be a big case. Maybe it's not contentious to you until it hits 20, but that is not the point. The point here is what Donna Adelson's motive was. And specifically, Linda Bailey had said at one point that she had had she had been representing a woman, and the woman's spouse, soon to be ex-spouse, committed an unaliving because of himself, because he was concerned about the shame that could come from this. And Georgia Kappelman said to her, well, you don't see divorce as shameful. And she said, no, I don't. And you wouldn't do that. But it was to him. It mattered that much to him. And so that was how he reacted, even if that wasn't how you would react. And so the witness said things like, let me go through it as Georgia did, said, wouldn't you admit that issues in these pleadings could make people really upset? Like the allegation that grandma is disparaging me. I mean, couldn't that be upsetting to grandma? And Linda Bailey said, well, it shouldn't have been. And in other words, saying it's not going to win. No one really thinks that. But Georgia Kappelman said, in your opinion, because obviously Donna Adelson might not know that, not having the same background. All right. So, but we were not done with the bizarre and weird things that happened today by a long stretch. There is a lot more to come. At lunch, I asked some questions of our group so you can kind of get a poll. I wanted to know, if the divorce was not that bitter, which is the point that they're trying to make, does that mean Donna doesn't have motive? And about 57% of you thought it was still possible for Donna to have a motive. Definitely possible for her to have a motive, even if the divorce wasn't all that bitter. And that then somewhat was 20%. So 77% of the people watching with me thought you can still have a motive if the divorce is not that bitter. That doesn't eliminate the motive for a murder, such as in this case. All right. Then I also asked, what do you think about these attorney witnesses? Were they effective? And 37% of you said not at all. 37% said not really. And then 18% said somewhat. And 6% said very effective. So I said, well, what about if you heard the judge give an instruction? Let's say you're a juror and the judge gives an instruction that someone sat in on testimony and they weren't supposed to do that. Would that be an important instruction to you? Would that make a difference? And 46% of you said very much. 26% said somewhat. And 14% said not sure. 12% said not much. Wouldn't affect me very much. But all day long, we were questioning, will Donna Adelson testify? Will it happen? What will be the result? Right after lunch, they put Donna Adelson, the judge put her under oath and made sure that she acknowledged and was admitting that she was waiving the attorney-client privilege of Marisol Descalzo, who represented her before and then shortly after she was arrested. I believe she said for the first 3 months after she was arrested. Marisol Descalzo was going on the stand this afternoon. So Donna waived the attorney-client privilege as to the things that were asked of her on direct examination. At this point, Donna was saying, I don't know if I'm going to testify. I don't know. And the judge is like, make up your mind. Decide. This is the time. This is the moment. Let me know. By the way, I asked, should Donna testify? It was a lot closer. 55% said no, and 44% said yes. But I think some of that may just have been yes, because I'd like to hear Donna, as opposed to yes on her own behalf. So we then moved into the testimony of Marisol Descalzo, who represented Donna Adelson from 2022 until 3 months after the arrest. She said that at some point there became concerns about Donna Adelson's mental state, that she was considering unaliving. It was of great concern. And their solution, she wanted to get away on a vacation. So where is this headed? Obviously to the question of whether or not when Donna Adelson was going to Vietnam, was she truly trying to flee the jurisdiction? Was she trying to get to a non-extradition country so she could avoid being prosecuted for something that she believed she was guilty of? Is this proof of her consciousness of guilt? That's what the state says. The defense is saying, look, she was going on vacation. Give the lady a break. So Marisol says there was, as far as she talked about this with Daniel Rashbaum, who was Charlie's attorney, and as far as I knew, there was nothing preventing Donna Adelson from traveling. There were no warrants for her arrest. And furthermore, Marisol had introduced herself to Georgia Kappelman and assumed they would contact her if they needed something, if they needed to let her know or ask for something. But she was very specific. At no point was she promised that or guaranteed that Donna would be able to self-surrender, meaning she could just bring herself down and just turn herself in. So on cross-examination, the Sarah Dugan handled this one, and she said, well, it's not necessary that you be notified before a client is arrested, right? And tried to get her to say that, in fact, that's probably not something you want to do when someone is maybe trying to leave the country. But the text that Donna wrote, where she said she was afraid she was next, but she'd take care of it, she asked about that. Sarah Dugan asked the witness about that. And the witness said, I'm not really familiar with that. I can't answer that. She said, look, we were worried about her in general. We were worried about her because she was worried about her son, not about conviction herself, but about her son. That's what we thought she was worried about. And we were told there was no warrant, but we warned her, both Rashbaum and I, that she could be arrested at the airport. And we didn't know. But as far as we knew, there was nothing holding her in the U.S. And that Marisol said she didn't know where she was going. She didn't know anything about non-extradition country or anything like that. So on redirect, they talked about the fact that Donna talked about vacation, not fleeing the jurisdiction. That's the point the defense wants to make. All she was doing was going out for a little break after the very difficult time with Charlie, and that extradition was still entirely possible. So even if Donna went to Vietnam, it wasn't like she had gone to the moon. There was still going to be the possibility of bringing her back and trying her in Tallahassee for this exact case. Maybe more difficult, but it's still possible. So the final witness, I believe this was final, was Sarah Newhouse. She was a victim advocate for Tallahassee back in 2014. She was assigned to Wendi Adelson on the day of Dan Markel's murder. Now, at various points, the defense has taken the position that the fact that Wendi was assigned a victim advocate is a sign that they saw her more as a victim and not as someone who is involved in the murder. I don't know if they made that as much of an issue in this case as in Charlie's, but it's been argued. But specifically, the defense wanted to ask Sarah Newhouse about the moment when Wendi called her mother. And Wendi called and specifically said, sit down, Mom. And Donna sounded shocked, according to Sarah Newhouse. It appeared to be the first time she'd heard about it. She sounded truly surprised by it. We did not see that moment during the call. They talked about it, but there was a little too much in it that the state wanted the sentence on either side of it taken out. So they're going to take those out, but they will be able to use that in closing argument if they wish to. So we spent, I would guess, maybe it wasn't that long. It seemed like half an hour with Donna Adelson trying to decide whether to testify. And they went back and forth and they said they needed more time. And this was really hard. And the state had presented 6 days of testimony, which is not really all that many, but they had to decide and they didn't know and they had to analyze it all. And the judge said, look, this is common to man. This is something every defendant has to deal with. Every defendant has to face the question of, are they going to testify or not? No defendant is given day of testimony for the state, full day to evaluate it and decide. There's nothing like that. Just when the state finishes and you finish your case or earlier, you have to make the decision. Are you going to testify or not? Give me your answer. And she couldn't do it. And they talked some more and they had a sidebar and she couldn't do it. And they came back and it went on. And finally, these final 5 minutes, and it was not the first final 5 minutes they had. But finally, she said, I do not wish to testify at this time. I do not want to testify at this time. And there you have it. The end. She was not going to testify, but it was hard. It was not a decision that anyone on the defense team came to easily. Quite clearly, they were not sure what they were going to do. They were not sure if she should testify or should not. They immediately ran into a little bit of a problem with an exhibit that would easily have come in with Donna, but there wasn't anyone to put it in related to her calendar. I think they got it worked out for the most part, but they will be missing little pieces like that, little pieces where they're not going to be able to get a fact in. Ultimately, I think it was the wise call, because even though Donna Adelson, granted, could have gotten in some of these extra facts, on the other hand, I think the cross-examination would have been utterly and completely brutal. No question about it. I think it would have been absolutely brutal. Tomorrow, we will be actually at the end of this case. We will actually have closing arguments. The jury will be instructed, and we will find out we may not find out the full answer, but the case will go to the jury tomorrow. As fast as the judge moves, my guess is that the jury will actually begin deliberations tomorrow. Now, in Charlie's case, that was super fast. We could actually have a verdict by tomorrow. We could know the result in Donna Adelson's case tomorrow. So do not miss tomorrow's live stream. We are doing gavel to gavel coverage, and it is going to be an unbelievably important case in the an unbelievably important day in the Adelson saga. So we will start in the morning when the court feed starts. I believe he wanted everybody there at 8:30. I can't remember for sure, but we'll start. We will start at the beginning. We will do gavel to gavel coverage, and I cannot wait to finish this and to watch this with you. If you would please hit the like button if you haven't already and subscribe. We would love to have you back for more.